We've been talking about Florida for a long time on this channel. It's shocking how many videos I have about Florida, considering that I do not live there. Like Kansas and Florida, the two states that I talk about the most. One of them I live in, the other one just happens to be leading our country toward the fash. But yeah, they keep doing things restricting, oh, here's what you can and can't say in schools regarding educating about gay and trans people. Here's what you can or can't do in the workplace sometimes. Like, oh, if you're a state employee, you don't get to have personal pronouns that differ from the ones that you were assigned at birth or whatever. In this instance, Florida tried to create, like a you can't talk about trans people in schools thing, and I think that was affecting how they were deciding how a trans teacher could be referred to. Like, I think the goal of that is definitely a part of the goal of that is to prevent gay and trans people from being teachers, or like gradually forcing them out. Because if you can't, quote, educate about hormones, or sorry, if you can't educate about pronouns or gender pronouns specifically, like transgender pronouns, then you would hypothetically not be able to educate students about your personal pronouns as a trans person. Like if you use they, them pronouns, then educating the students and saying, well, here's what it means. It means that I identify as non-binary, blah, 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 blah. That could be seen as a breach of the Don't Say Gay bill that they made. And so that's what is kind of running through the courts now. If you're enjoying this video, hit the like button, maybe subscribe, hit all notifications if you want. Feel free to check out the links in the description. You might find some merch you like, or you can hit up the Patreon to support the content and find free stuff. This judge has determined that a transgender teacher cannot be forced to go by a pronoun that they do not prefer. Like the judge ruled that she's allowed to be called Ms. and can use female pronouns in the classroom. Previously, there was a requirement at the school that the teacher be referred to as Mr. or just teacher in the classroom. But this is not acceptable based on the First Amendment protections. And I'm not sure if it's like speech protections or if it's expression. We'll see as we go further in. She's allowed to use Ms. and female pronouns. This decision follows the passage of this bill, which mandated that teachers could not use pronouns that, quote, do not correspond to his or her sex. Okay, so they made a specific law that says teachers are not allowed to identify with pronouns that do not respond to their sex at birth. This judge, Mark Walker, enjoined the state from enforcing the law against this teacher, stating, quote, the state of Florida has not justified this grave restraint, and so the United States Constitution does not tolerate it. Ours is a union of individuals celebrating ourselves and singing ourselves and being ourselves without apology. That's a pretty wild positive statement. This plaintiff has been known as Ms. Wood for 4 years. She regularly would write her name, title, and pronouns on the whiteboard, and she used these pronouns with the students, faculty, and staff, as well as in the personal life. In evaluating Ms. Wood's usage of her name, title, and pronouns, the judge determined, quote, the freedom to use the title Ms. and to share her preferred pronouns at school is essential to her basic humanity. The judge commenced the ruling with a scathing critique of the state, writing, quote, once again, the state of Florida has a First Amendment problem. It has occurred so frequently of late, some might say you can set your clock by it. The question before this court is whether the First Amendment allows the state to dictate, without limitation, how public school teachers refer to themselves when communicating with students. The answer is a thunderous no. I'm 100% positive that they are going to continue trying to appeal this up. So the state of Florida has lost this case, saying no, based on the First Amendment, you cannot prevent a teacher from using gender pronouns of their preference in the school setting, and you cannot force them to go by a title that they don't want to go by. It would be like the state reaching in and saying you're not allowed to go by this name. Like those are just the terms of address that you have. That's how you refer to you. It's like weird that it's considered negotiable in this society. It's like you just call me what I am called. I am called Luxander. Call me by that. It may or may not be my legal name. Like nobody, like it doesn't matter for you to know. And then with my pronouns also, it's like I'm teaching you how to refer to me. You refer to me in a particular way so that I can just exist in the world. Like this judge, any of these specific comments that Aaron has included so far have not specified like under which part of the First Amendment this is being ruled. Okay, here it is. The judge ultimately determined that prohibiting Ms. Wood from using her pronouns or title constituted an unconstitutional violation of her freedom of speech, deeming it a form of viewpoint discrimination. In the decision, he refuted several arguments presented by the state, including the claim that Ms. Wood using Ms. would, quote, impede her job duties. How? He found this assertion to be unfounded, noting instead that as a teacher, Ms. Wood's students achieved test scores higher than the district average. Boom! Trans excellence. It's so crazy when they try to discredit us, and then it's like, actually, we are the best. Like, actually, we excel. Actually, we're amazing. Obviously, not every trans person is, like, incredible and amazing, but because we're just people, there's good ones and bad ones, whatever. But it's just really vindicating in this context. Like, oh, using these name and pronouns is going to impede her duties. Nope, actually, she does better than the district average. The state also argued that Ms. Wood's identity itself was at odds with the state's teaching on gender and sexuality, and thus she could be barred. This argument, based on a novel legal theory, which means a new legal theory, was found by the judge to be entirely unsupported by previous precedent. Apparently, there is also other legal action addressing this topic, because the 11th Circuit Court of Appeals recently ruled that repeated and intentional misgendering could constitute a hostile work environment. Yeah, that's the only means by which this is ever addressed in law, by the way. The using pronouns at work thing, it's because you're creating a hostile work environment if you repeatedly refer to someone as something they don't want to be called. If you have a coworker named William and you refuse to stop calling him Billy, even though it really pisses him off, he could have you punished by the company for creating a hostile work environment, for harassment. It's like, I keep telling you my name is not Billy, my name is William, and I've told you like 6 times now, like, you're really getting on my nerves with this, you know? It's the same level of protection that trans people get in the workplace when it comes to pronouns and names. It's just that these people think that it should be acceptable to be transphobic, basically. They're like, yeah, but it's my deeply held transphobic belief. That's their whole argument, essentially. The 7th Circuit Court of Appeals also recently determined that teachers do not have the religious right to misgender trans students. So this Florida case did not grant Ms. Wood an injunction on the basis of a hostile work environment. It does not preclude the possibility that it might recognize she experienced such an environment in addition to the First Amendment violation identified by the judge when the case is fully heard. So this is like a preliminary thing, and she has been granted an injunction, as in this law does not get to be applied to her. So this injunction only applies to her. That's a good point to notice. Like, other teachers might be having their pronouns restricted in the workplace, and this case is only putting a pause for her, not for other trans teachers in the state. And this is just a preliminary injunction, so we'll see what happens when the case is more fully reviewed. But it seems like the First Amendment argument is going to be central to it. Not necessarily the hostile work environment part, but... And so I think that that's a stronger case, honestly. I think if you're going with a, First Amendment argument, referencing the Bill of Rights, as opposed to more local rules that might shift and depend, like, oh, okay, is it harassment? Is it a hostile work environment? Whatever. But like a First Amendment violation means that law cannot exist anymore because of the Constitution. So if we get a more thorough ruling, it would be great if this is struck down on that basis. And then, of course, the state of Florida is going to continue to appeal, and we'll just have to see how it goes from there. As with all of these cases, it's good to see, though, that in the various circuit courts of appeal, they are generally finding that you can't discriminate against trans people for no goddamn reason. So we can keep our fingers crossed that these judges, and frankly, even some of these Trump-appointed judges, are sticking with reason and, in my opinion, justice on this matter, making sure that trans people have equal rights and protection under the law, that we have an equal right and protection in the workplace. Like, in a system where you have to eat in order to survive and you have to buy food, you cannot bar people from employment. Like, if you create a hostile work environment so that they can't functionally work, that is like imperative to their life. they will not be able to continue in the same capacity. So we need to have the rights and protections to ensure that we can provide for ourselves. Yeah, I hope that this pans out fully because trans Floridians need a W. Like, at the very minimum, workplace protections. There is not necessarily a First Amendment right to receive trans health care. We might have to depend on the 9th Amendment and the 14th Amendment for that. But we do have a First Amendment right, hypothetically, to express ourselves and to not be compelled in our speech. And I think that forcing someone to go by a certain name or pronouns is a type of speech violation, or compelled speech or something. So yeah, good times, great oldies. Nice to get some good news today. Thank you, my patrons, especially Tiago Nascimento, Mersh Rolvog, Amanda B., Michelle Frateroli, Wellington Marcus, Michelle Winter, Danielle McDonald, Suzanne Maynard, DZXN, Spooky Heather Sylvia, Ella V. Nobody, Pasnell Infinity, Jamie Jam, Sojo, Nova, Elizabeth Bartell, Athiet, Kevin Young, Desi Quiche, Celeste, Liam Hodgson, and Mr. Atheist.